Hi, it's Kirby Clements, and I want to talk with you about the 10-day rule in DUI cases. No doubt, you've read other lawyer websites about what the 10-day rule is. I want to tell it to you verbally so that for some of you, it might help you to understand it a little bit better. Here is what the 10-day rule means. If you refuse to take the state administered breath test, or if you took the state administered breath test and blew a .08 or higher, then you have 10 days from the date of your arrest to file an appeal. If you don't file an appeal, your license is going to be suspended on the 31st day. Here's how it works. The officer places you under arrest. The officer says, take the breath test. You say, I'm not taking the breath test. They fill out a form. It's called a Form 1205. It's on a regular size sheet of paper like this, 8.5 by 11. Your copy might be pink or yellow. Depends on which one the officer happened to give you. I mean, it says which form he's supposed to give you, but I've seen all different shades. But anyway, the officer will serve you with that form. And when you get out of jail, that officer will have mailed that form off to the Department of Driver Services. They're going to get that form and they're going to wait 10 business days from your arrest to find out whether you filed an appeal. If you don't file the appeal on day 31, your license is going to be suspended. Now, that form tells you this is a temporary driving permit, but it's a temporary short-term driving permit you've got for the next month to drive. So please file the appeal. Now, if you blew .08 or higher, your license is still going to be suspended because you blew above the legal limit. And that Form 1205 will still be mailed in to the Department of Driver Services, and they will suspend your license on the 31st day. Now, the 10 days are 10 business days. That means if you get arrested on a Friday, then Monday is the first business day. And then that following Friday is the fifth business day. And then that next week, that Monday will be the sixth business day. And that following Friday will be the 10th business day. So you actually have a lot more time, but don't waste time. That's important that you understand that. It needs to be postmarked. You have to mail your appeal and pay the $150 fee to the Department of Driver Services. The form itself tells you where to mail it. It goes to the Department of Driver Services in Conyers, along with your name, your address, your telephone number, your driver's license number, and indicating that you wish to appeal the administrative suspension. Now, let me tell you some basic rules that you should follow. Rule number one, if you didn't get the form, but you know you refused the test, file the appeal. Pay the $150, mail it in, file the appeal. Two, if you blew .08 or higher, file the appeal. Even if you don't have the form, file the appeal. And the reason that I say do this is because many times officers will leave the paperwork at the jail and the jail may not give it to you. And I've had that happen to clients where I've called the jail and the police department to ask, did you give my client this form? And I've had them tell me no, or that we don't have to give them the form. It's up to the officer's discretion. They've told me a lot of different things. And we filed the appeal only to find out, yeah, in fact, the officer had submitted the paperwork. So here are the rules that you should take away. Rule number one, if you blew a .08 or higher, file the appeal, pay the fee. If you didn't blow it at all, didn't take any test, file the appeal. If you refused and they got a search warrant and they got your blood, file the appeal because it still counts as a refusal. That's very important that you understand. Now, the next thing that I want you to understand is this. They're going to set your case down for a hearing. So if you file the appeal, there's going to be a hearing in front of an administrative law judge where they're going to argue facts and the law at that hearing. You're going to need a lawyer for that hearing. You can also go to that hearing and you can see if you can get the officer to agree to withdraw that suspension in exchange for a guilty plea. But why would you want to do that without knowing whether they have a good case or not? Now, let me explain to you how serious these suspensions are. An ALS suspension is a hard suspension. That means for a year, you can't drive at all. Not to work, not to school, nothing. You cannot drive. Whereas a DUI suspension is a soft suspension. A first offense DUI, you're eligible for a limited driving permit, which means you can drive to and from work, things of that nature. You won't lose your job. So filing this administrative license suspension hearing request is imperative. You must do it. So if you have been arrested, charged with DUI, you refuse the test, or you took the test and blew 0.08 or higher, file it. I strongly recommend that you get a lawyer because there are a lot of technical things that go into play when you're having these types of hearings. And there's discovery that you can file to find out more about your case that will help you not only with the administrative hearing, but may also help you with the DUI, criminal part of the case. But it's very important that you get a lawyer. You can call me at 404-212-1928. But let me, as I say all the time, if you can't hire me, you need to hire somebody. Don't do this alone. Thank you very much for watching. I hope you found this very informative.